Good morning and good afternoon, folks. I'm Sabrina Veldner, and on behalf of McGuireWoods, I'd like to welcome our U.S. and UK-based attendees to today's webinar on seminal LGBTQ+ legal cases in the United States and the United Kingdom. This programming is being brought to you as part of McGuireWoods Visibility Week during Gay Pride Month. Today's presenters are 6 McGuireWoods lawyers from our LGBTQ Lawyers Network. Myself, partners Wanda French-Brown, William Boddy, and Todd Dressel, and associates Carly Starr-Blank and Olivia Kilner. Before we begin, we would just like to cover a couple of housekeeping matters. First, if you are an attorney attendee seeking CLE credit for this presentation, we will be applying for CLE credit on your behalf in the states you identified and based on the information you provided with your registration. Second, attendees may submit questions during the presentation. To ensure we cover all of the material, we may defer answering questions until the conclusion of the program or provide answers in a follow-up communication. Of course, you may always contact any of the McGuireWoods presenters if you have questions on the materials covered today. With that, I will jump into a brief overview of today's programming. First, we're going to talk about the cases that led into the Supreme Court's decision last week in the Bostock case, and then we're going to talk about other LGBTQ+ cases to be on the lookout for in 2020. We're also going to cover the landmark U.S. Supreme Court cases that have shaped LGBTQ rights in America. And then we're going to take a step across the pond, and we're going to talk about LGBTQ rights in the United Kingdom and summarize how those rights have been established by United Kingdom case law and legislation. Now, I'd like to jump into the Supreme Court's Bostock opinion, which is actually an opinion in 3 consolidated cases. And in order to fully understand that opinion and how it got to the court and what its holdings were, we need to go through the 3 underlying cases. The first of which was Altitude Express Inc. versus Zarda. That's a case that originated in the Eastern District of New York and made its way to the Supreme Court via the Second Circuit Court of Appeals. In Altitude Express, Don Zarda was a tandem skydiving instructor who would jump with skydiving participants. And when he would have a female customer who would be strapped to him for her skydive, he would sometimes tell the customer that he was gay to make them more comfortable with the close contact. When he did this in 2010, a woman's boyfriend complained about the comment to Altitude Express, and he was fired. Following his termination, Don sued under Title VII of the Civil Rights Act in New York state law, alleging that he was terminated due to his sexual orientation and for failing to conform to male sex stereotypes. The case at the Eastern District of New York level, summary judgment was granted to Altitude in 2014, with the court holding that Title VII's sex discrimination prohibitions do not include sexual orientation. In other words, the court essentially said that because sexual orientation was not one of the listed traits for Title VII, it was not entitled to Title VII's protections. Shortly after that decision, Don Zarda actually passed away in a base jumping accident. So this case has continued on from 2014 to now by Don's family. When the case made its way to the Second Circuit in 2017, the case was initially affirmed based on the same grounds, that Title VII simply did not protect and prohibit discrimination based on sexual orientation. And the following year, the case reached en banc status with the Second Circuit, and a 13-judge en banc panel in the Second Circuit held that Zarda could pursue a Title VII claim based on his sexual orientation, as they decided that sexual orientation was but a, quote, subset of sex discrimination under Title VII. In that decision, the court reasoned that sexual orientation is a function of sex, and sex is a protected characteristic, and so too is sexual orientation. And the court also reasoned that to fire a man because he is attracted to men is a decision motivated at least in part by sex. Now, following that en banc decision, which was actually an overruling of prior Second Circuit precedent to the contrary, certiorari was pursued to the United States Supreme Court, and that was granted in April of last year. The second of the 3 cases that was the resulting Bostock decision from the Supreme Court is the RG and GR funeral homes case. This case came from the Eastern District of Michigan and worked its way through the Sixth Circuit before winding up at the Supreme Court level. And this case presented the issue of whether Title VII protected against discrimination based on someone's transgender or transitioning status. In this case, the EEOC was actually the party that commenced the lawsuit under Title VII, and they did so on behalf of Amy Stevens, alleging that she was terminated due to her transgender status and gender stereotypes, and that the employer had a discriminatory clothing allowance policy. By way of background, Amy Stevens had originally been hired by the G&R Harris Funeral Homes as Anthony Stevens, someone who had been born biologically male, and had been hired to work as a funeral director for that funeral home, which happened to be a for-profit funeral home. Stevens was terminated shortly after telling the funeral home owner that she was going to transition to female and planned to dress as a woman at work following that transition. And at no point in the case was the funeral home's motivations at issue. The funeral home owner admitted firing Stevens because she was no longer going to represent as a man and wanted to dress as a woman, and the owner considered it contrary to his religious beliefs. So at the district court level, the district court granted summary judgment in favor of the funeral home, despite finding that Stevens was discriminated against on the basis of sex in violation of Title VII. You may ask yourself why that was. The reason that was that the court held that the Religious Freedom Restoration Act prevented the EEOC from enforcing Title VII against the funeral home because to do so would substantially burden the owners and the funeral home's religious freedoms. And the court found that the EEOC had not demonstrated that Title VII enforcement was the least restrictive way to protect Stevens in the workplace. The court had also held on a motion to dismiss that the EEOC could not sue for discrimination based on transgender status because that was not a protected trait under Title VII. Now, when this decision made its way to the Sixth Circuit reversed essentially on all counts. The Sixth Circuit stated that the district court correctly held Stevens was discriminated against due to gender stereotypes, but that it erred in finding that transgender and transitioning status were not protected under Title VII. The district court rejected the application of the Religious Freedom Restoration Act application and granted summary judgment in favor of the EEOC. So what happened at the Sixth Circuit was they held that the Religious Freedom and Restoration Act that had essentially been accepted as the defense was not an acceptable defense. And they essentially reversed the ruling, not just reversing the holding, but actually reversing the holding such that they were automatically granting summary judgment to the EEOC on the unlawful termination claim. What the Sixth Circuit said was, look, Title VII's prohibitions do not substantially burden the funeral home owner's exercise of his religious freedoms. And even if they do, Title VII is essentially the least restrictive means to further the government's compelling interest in eradicating workplace discrimination. Now, at the circuit court level, the funeral home was still advancing religious arguments, and one of those was the ministerial exception to Title VII. And the circuit court held that Stevens, as a funeral director at a for-profit funeral home, was not a ministerial employee, and the funeral home did not qualify for the religious organization exemption under Title VII. Now, the last of the three cases, and the namesake for the U.S. Supreme Court's case, was the Bostock versus Clayton County case. This case emanated from the Northern District of Georgia, and it wound its way through the 11th Circuit Court of Appeals before it made its way to the U.S. Supreme Court. In this case, Bostock had been a 10-year county employee who worked as a child welfare services coordinator, and during that time, he had good reviews and accolades. He was terminated in 2013, allegedly for conduct unbecoming a county employee after an audit was commenced into his expense practices. Now, prior to that time, several of his coworkers started making comments in the workplace about his sexual orientation and his involvement in a gay softball league known as the Hotlanta Softball League. It was the gay men's softball league within the city of Atlanta. And after his termination, Bostock filed an EEOC charge and actually commenced the lawsuit on his own behalf. claiming he was discriminated based on his sexual orientation in violation of Title VII. He later obtained a lawyer and amended to add allegations of discrimination for failing to conform to the gender stereotype. Now, in this case, a motion to dismiss at the district court level was granted with prejudice in 2017, with the court essentially relying on their prior circuit court authority, which held that Title VII does not protect against sexual orientation discrimination. Essentially, the law of the 11th Circuit in which the district court fell was that Title VII did not have a specifically enumerated protected trait of sexual orientation discrimination, and therefore it was not protected. When the case went up to the 11th Circuit on appeal, the decision was affirmed in a very, very short per curiam opinion. The court basically held there was no error in the court's ruling at the district court level because its prior precedent foreclosed such a sexual orientation discrimination claim under Title VII. And unlike the Second Circuit in the Altitude Express case, the 11th Circuit declined to review the case en banc. And ultimately, cert was granted in the Bostock case on the same day as Altitude Express and RG, and all three were then consolidated for oral argument and decision in front of the Supreme Court. So what happened next? I think we all know this. Gorsuch gets textual. Last Monday, the decision was issued by the U.S. Supreme Court in Bostock versus Clayton County, and in a 6-3 decision, the Supreme Court held that an employer who fires an individual merely for being gay or transgender violates Title VII. Now, for those of us who followed these cases, I don't think the actual holding was much of a surprise. I think the surprise may have been that it was a 6-3 decision and not a 5-4 decision, and there was definitely a surprise that Justice Gorsuch wrote for the majority and authored the opinion. But he did take a very textual authorship, and he adhered very strictly to the plain language of the statute in his decision. There were 2 dissents that were authored by Kavanaugh and Alito. Thomas joined in Alito's dissent on the opinion. And in Gorsuch's majority opinion, this quote from that opinion essentially summarizes what the court had to say about Title VII and what it means. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. What the court held in its ruling and in Gorsuch's opinion is that the plain language of Title VII protects decisions that are made because of or on account of sex. And, quote, homosexuality and transgender status are inextricably bound up with sex. Now, the employers in the Bostock case presented various different challenges and pursued a more narrow interpretation of Title VII and challenged the statute's intent, but the court held steadfast to Title VII's starkly broad terms based on the plain language of the statute. Now, in doing so, they rejected a number of different arguments, and I'll just run through them so you understand them quickly. The court rejected an argument that because the employer would terminate both women and men, that it was not a discriminatory policy in any sense. And what the court held was that firing a female for being a lesbian and firing a man for being gay, they don't cancel each other out or make the act any less discriminatory. Rather, that's a doubling down on discriminatory decision-making and a doubling down on legal risk. The employers also advanced an argument that none of these plaintiffs would have described the decision made as to their employment to be sex discrimination in ordinary conversation, and thus it shouldn't be treated as such by the court. And the court was very quick to dismiss that. The court said most people wouldn't conversationally describe their separation, in that kind of detail, and that this was a really unimportant distinction because the question that Title VII poses is simply whether sex was a but-for cause for the decision. Another argument that the employers presented was that this wasn't any intentional discrimination based on sex in the form such as is required by a disparate treatment claim. And what the court said was these are not class claims that are being presented by these individuals, and the way Title VII has been written is to prescribe discrimination against an individual, not a group. And the employer's intentions beyond the individual claimant or the employer's preferred self-labels for its motivation are just not relevant to the court's analysis. The employer also argued that the sexual orientation and transgender status just had not made the list of Title VII's protected traits, and their absence from that list meant they were not and should not be protected. And the court dismissed this argument and said, if we were to accept that, then the notion that Title VII prohibits sexual harassment would also have to fall by the wayside because sexual harassment is also not on the list. And finally, there was an argument made by the employers that this wasn't the drafter's intent in the 1960s when Title VII was enacted. They weren't intending to protect transgender status or sexual orientation. And the court summarily dismissed this argument. It essentially said, we have already interpreted and applied Title VII more broadly than to what the intent would have been in the drafting of the statute 50 years ago. And it cited its decision in Oncali, which was a case where the court held that Title VII prohibits male-on-male sexual harassment. And the court said, if we were to adopt this logic that the law should be determined based on what the intent was at the time of drafting, this would render our prior and well-accepted decisions expanding Title VII, like in Oncali, to be basically judicial mistakes. And so it rejected that argument as well. So this was, without question, a big victory for LGBTQ plus individuals in the workplace, but it does not end everything. There are still issues left after Bostock, and certain of those actually came up towards the end of the majority opinion. First, the employers had made an argument that if the court were to decide the case in favor of broad application to protect against sexual orientation and transgender status, that this decision would effectively prohibit sex-segregated restrooms, locker rooms, and dress codes. In other words, it would just sort of be a domino effect. The court basically sidestepped that and said, in its majority opinion, that none of these issues were before it, and we don't prejudge any such questions today. So we can and should expect that issues such as that will make their way to the court in coming years. And then there's the question of what about religion? The funeral home case of the three had been the only one that had any religious aspect on it, but the religious challenges that had been levied by the employer were not part of the cert petition to the Supreme Court, and so they never made it there. And so here's what the court said in Bostock about what religion plays into its decision. The court basically acknowledged that it is, quote, deeply concerned with preserving the promise of the free exercise of religion. But then it declared that how the protections of religious liberties will interact with Title VII is a question for future cases. Right? The court basically said this has not made it to us on this case today. It's not part of Bostock or Altitude or RG, but it will eventually get here, and it is something to be decided on another time. So how the free exercise clause in the Constitution for religion will apply as a defense, that remains to be seen. How the Religious Freedom Restoration Act and its protections may or may not supersede Title VII also remains to be seen. And how the religious institution and ministerial exceptions to Title VII might apply in another future case with an LGBTQ plus individual also is an issue that can and likely will make it to the court in the coming years. So those battles all remain for another day after Bostock. With that, I'm going to turn it over to Todd Dressel.
Thanks, Sabrina. I'll be discussing the Drew Adams versus the School Board of St. Johns County, Florida. It's out of the United States District Court in the Middle District of Florida. Drew's case became the first lawsuit involving a transgender student's equal access to restrooms to go to trial. And in July 2018, the Federal District Court in Florida vindicated Drew's right to equal educational opportunity, including equal access to the boys' restroom while at school. Drew had been living as a boy that he is since 2015, Before entering the Alan D. Neese High School in Ponte Verde, Florida, his mother informed the school administration that he would be joining the school as a boy. He used the boys' restroom when he started his freshman year without any incident. But later, 2 girls anonymously reported that he was using the boys' restroom, and he was told, in accordance with district policy, he could only use the general neutral restrooms, which separates him from his peers and treats him as unfit to share communal facilities with others. For 2 years, Drew monitored his liquid intake, where his classes were located, all to avoid as many trips as possible to the general neutral restrooms, as well as dealing with their limited locations. In August 2017, Drew was 16 years old and beginning to enter his junior year when he decided to file suit. On behalf of Drew, Lambda Legal argued that St. John Board's discriminatory restroom policy sends a purposeful message that transgender students in the school district are undeserving of their privacy, respect, and protections afforded to the other students. Lambda Legal also argued that the school district's policies to exclude transgender students from the restrooms that match their gender is unconstitutional because it discriminates based on sex in violation of the Equal Protection Clause of the 14th Amendment and Title IX of the 1972 Education Amendments Act. In July of 2018, Federal District Judge Timothy Corrigan issued a detailed 70-page decision not only establishing why Drew must be allowed to use his correct restroom, finding on both the Equal Protection Clause and Title IX claims of Drew's complaint, also issuing an injunction against the district to enforce the policy, but he also, in great detail, dispelled the factual myths that were raised in the district arguments. The school board obviously appealed. Next slide. On appeal, the district argued the following: whether or not the school board's policy of barring boys who are transgender, such as Drew Adams, from the boys' restroom violates equal protection guarantees of the 14th Amendment. The school board's policy of barring boys who are transgender, such as Drew Adams, from the boys' restroom violates Title IX of the Educational Amendments of 1972. The matter was fully briefed, and obviously, given its significance and timing, there were numerous amicus briefs filed in support of Drew as well. And in early December 2019, the 11th Circuit Court of Appeals heard oral arguments, and it appears the parties were just waiting for a decision. Now, given the Bostock decision on the 17th, the 11th Circuit has now has requested additional briefing as a result. So I think, as Sabrina said, we're still waiting to see how far the Bostock decision will go, and we shall see. And I'll pass it off.
Thank you. We're now going to turn to 3 HIV-positive military service cases. And just for background, DoD policies dating back to 1991 restrict HIV-positive service members' deployment rights. Specifically, they're categorically defined as non-deployable and are required to be stationed within the continental United States unless they obtain a medical waiver. However, no such medical waivers have ever been granted, and they're presumed to be unavailable to HIV-positive military members. The categorical ban on deployment of HIV-positive military personnel proved to be highly problematic in February 2018, when then Defense Secretary Mattis announced the Deploy or Get Out policy. Pursuant to that policy, all service members must be worldwide deployable, and those who have not deployed in the last 12 months may be targeted for separation. Suddenly, all HIV-positive service members faced an immediate risk of discharge under Deploy or Get Out. The 3 military service cases we'll discuss today principally challenge the discharge of these members without an individualized determination of fitness for service. While none of the cases directly challenged Deploy or Get Out, it catalyzed the filing of each case by HIV-positive members of the Air Force, Army, Navy, and National Guard who suddenly found themselves summarily discharged from the military. Next slide, please. Rowan Bowe versus Esper is the first and most notable of the HIV-positive military service cases, as it went up to the 4th Circuit and secured a victory for all active duty HIV-positive members of the Air Force. Richard Rowe, Victor Bowe, and 4 additional unnamed plaintiffs enlisted in the Air Force before they contracted HIV. Upon receiving their HIV diagnoses, They underwent standard disability assessments, and it was determined for each of them that there was no medical reason why these airmen could not be returned to duty. Despite the lack of any individualized basis for finding the airmen unfit for service, the Secretary of the Air Force Personnel Council concluded that their HIV status precluded them from being able to deploy worldwide without a waiver, and thus rendered them ineligible for deployment to the Central Command area of responsibility, where the majority of Air Force members are expected to deploy. In 2018, all 6 airmen filed a complaint in the Eastern District of Virginia alleging that the military presumed, in violation of the Administrative Procedure Act, that anyone with HIV would be unable to obtain a medical waiver from CENTCOM and is therefore ineligible for deployment to the CENTCOM area of responsibility. The district court concluded that the categorical determination against all HIV-positive service members violated the Administrative Procedure Act standard, as it deprives the service members of their right to an individualized determination of fitness and failed to use objective evidence of their physical conditions, symptoms, treatment requirements, and transmission risks pursuant to DoD-mandated discharge procedures. Notably, the court issued a nationwide preliminary injunction prohibiting the Air Force from separating or discharging Roe, Zoe, or any of the other plaintiffs to military service, and extended the scope of the injunction to protect any other similarly situated active duty member of the Air Force because they're classified as ineligible for worldwide deployment due solely to their HIV-positive status. On appeal, the Fourth Circuit affirmed the decision and upheld the injunction, finding that the categorical classification preventing HIV-positive airmen from deploying was predicated on outdated medical evidence and therefore arbitrary and capricious. Specifically, the Fourth Circuit highlighted the near impossibility of transmitting the virus through the battlefield exposure, particularly when service members are actively taking their antiretrovirals and have a nearly undetectable viral load. In upholding the trial court's grant of a nationwide preliminary injunction, the Fourth Circuit cited the trial court's explanation of the unique characteristics, stigma, and discrimination against all those living with HIV, which may pose a challenge for others similarly situated to bring suits on their behalf. Next slide, please. This companion case seeks to enjoin the military from relying upon HIV status to deny an officer commission to a service member who was offered that position despite their HIV status. Sergeant Nick Harrison, who served 2 tours of duty, always wanted to be a judge advocate general for the D.C. National Guard. He completed his legal education, and around the time he passed the bar exam, he was diagnosed with HIV. Despite his diagnosis, he was offered a position in the JAG Corps for the D.C. National Guard, which he accepted. While he adhered to antiretroviral treatment and maintained an undetectable viral load, the Army refused to commission Harrison as a JAG officer, citing DoD Instruction 6485.01, which prohibits the commissioning of HIV-positive individuals as officers. In response, Harrison filed a single-count complaint alleging that the military's disparate treatment of HIV-positive service members deprives them of their right to equal dignity and stigmatizes them as second-class citizens in violation of their Fifth Amendment equal protection guarantees. The government has moved for summary judgment, which Harrison timely opposed. An oral argument on that motion is scheduled for July 31st, 2020. A ruling on the merits may not come until 2021. Stay tuned. Next slide, please. In the second companion case, it involves 2 military cadets who were diagnosed with HIV prior to graduation. They're in a particularly precarious position as, if they had enlisted in the military and were then diagnosed with HIV, they could remain enlisted. But since they did not enlist and are cadets in those military academies, they are precluded from being commissioned as officers because service members' HIV-positive status prevents them from being commissioned to any officer position. Despite glowing recommendations from their commanding officers and findings of medical fitness in all regards, they were still denied a commission at graduation on the basis of their HIV status. D.C. filed a complaint alleging violations of the Administrative Procedure Act, as well as procedural due process claims under the Fifth Amendment. Briefing on the government's motion to dismiss concluded on March 13, 2020, so keep an eye out for ruling on that motion. Next slide, please. There are four main takeaways from the HIV-positive military service cases, each of which are at the intersection of military policy and medical advancements in HIV treatment, consistent with the Fourth Circuit's reasoning in Roe and Bowe versus Esper. First, the role of antiretrovirals. As the Fourth Circuit explained, policies dating back to 1991 prohibiting HIV-positive service members from deployment are justified on outdated science that ignores current medical evidence, including antiretroviral medications that reduce Roe and Roe's viral level to an undetectable level, left them asymptomatic, and allowed them to be found fit for deployment in each medical evaluation they underwent. Second, there's effectively no risk of transmission by HIV-positive individuals who are on antiretroviral treatment once their viral load has been effectively suppressed. The Fourth Circuit specifically cited that the risk of transmission is essentially reduced to zero under those conditions, and that the risk of transmission is even lower in the battlefield context, where HIV may not even be transmittable. Medical breakthroughs. The advent of PrEP and PEP prevents prospective LGBTQ youth from contracting HIV, even if directly exposed to it. These medications may benefit such youth who aspire to military service but are at higher risk of exposure to HIV. It could be particularly useful for military academy cadets, as shown in the D.C. companion cases. The Fourth Circuit's ruling against the Air Force in Roe and Bowe versus Esper is binding precedent for the district court's hearing on the companion cases and may provide the legal support necessary for the district courts to enter similar nationwide injunctions against additional branches of the military. Next slide, please. Moving now to non-binary identity documents and the 10th Circuit's recent decision in Zinn versus Pompeo, I want to take a moment to explain what non-binary means. It is a third sex designation, usually represented by the letter X, that encompasses a broad cross-section of individuals, including those who are medically considered non-binary, or who are born intersex, whose gender identities differ from their sex assigned at birth, as well as individuals who have characteristics of both genders, and those who do not identify with any gender. Next slide, please. Dana Zim, who is identified as intersex at birth, was raised as a boy, explored living as a woman in adulthood, but is most comfortable identifying as intersex. Zim, who uses the preferred pronouns they, them, and theirs, applied for a passport as an intersex individual. On their application, Zim wrote intersex in lieu of checking either the male or female box, and included a letter explaining why they wanted an X sex designation on their passport, and included physician letters attesting to their intersex status. The State Department rejected Zim's application for a passport, citing their binary sex policy. The State Department gave Zim three options: apply as female, using their Colorado driver's license; apply as male, if a physician attested that they had transitioned to become a male; or withdraw the application. In response, Zim filed suit in the United States District Court for the District of Colorado. In Zim's complaint, they alleged that the Department of State's binary sex policy exceeded the State Department's authority under the Passport Act of 1926, that the Department of State's reliance on the binary sex policy was arbitrary and capricious under the Administrative Procedure Act, and that the binary policy violated the Constitution. The trial court concluded as a matter of law that the Department of State violated the Administrative Procedure Act in two ways. First, because adherence to the binary sex policy exceeded their statutory authority, and second, because application of the policy to Zim was arbitrary and capricious. The district court granted a permanent injunction against DOS's enforcement of the binary sex policy as to Zim. On appeal, the 10th Circuit reversed, in part, finding that DOS had statutory authority to deny the passport application based on its binary sex policy. However, the 10th Circuit affirmed the trial court's conclusions that the Department of State had violated the Administrative Procedure Act, as 3 of the 5 grounds relied upon to justify denying the passport were not supported in the record, and therefore reliance on a binary sex policy was arbitrary and capricious as to those 3 grounds. The 10th Circuit vacated the judgment for Zinn and the permanent injunction and remanded with instructions for the trial court to consider Zinn's application under the 2 remaining grounds that were supported by the administrative record. Those 2 grounds are, 1, that the binary sex policy helped identify individuals ineligible for passports, and 2, that the binary sex policy helped make passport data more useful for other agencies. The remand proceeding should proceed shortly. Next slide, please. Regardless of the outcome of Zinn's case on remand, recently proposed federal legislative reforms, such as the Gender Inclusive Passport Act, are encouraging developments for the non-binary community, which may provide a non-judicial avenue for overturning the State Department's binary sex policy. The above takeaways speak to the 10th Circuit's reasoning in rejecting 3 of the 5 rationales that the State Department provided to justify denying Zinn the non-binary passport, on the basis that each was unsupported by the record. First, the administrative record failed to support the government's argument that the binary sex policy ensured accuracy and reliability of passports. Rather, the 10th Circuit concluded that a passport would be more accurate and more reliable if non-binary individuals could use a 3rd sex designation of X. In support of that conclusion, the Circuit Court cited 13 states that offer non-binary birth certificates and driver's licenses. As a second matter, the 10th Circuit rejected the argument that creating a 3rd sex designation, or X, was not feasible. As the 10th Circuit noted, the International Civil Aviation Organization, or ICAO, allows nations to use a 3rd sex designation of unspecified on passports. Thus, an X gender designation could be added to American passports, and those passports would be valid worldwide. Finally, the Gender X is broadly defined. The breadth is conducive to the establishment of procedures within the DOS to verify an applicant's X sex designation with minimal additional burden on the state. Next slide. Thank you.
Hi. Next slide, please. So the next 2 cases relate to adoption and foster care. In Morris v. Azar, a same-sex couple from Texas was denied the opportunity to apply to serve as foster parents for refugee children because, as they were told, they did not mirror the Holy Family by the Catholic Charities of Fort Worth. Plaintiffs allege violation of the Establishment and Equal Protection Clauses, as well as violation of substantive rights under the Due Process Clause. Next slide, please. State defendants moved to dismiss for lack of standing, given that the Catholic Charities of Fort Worth was a private agency that simply received government funding. The motion to dismiss was denied because plaintiffs were harmed as individuals, and on that basis, the couple may pursue their constitutional claims. Next slide, please. In Rogers v. U.S. Department of Health and Human Services, a married lesbian couple was turned away by a government-funded foster care agency that excludes prospective foster parents who are not evangelical Protestant Christians or who are same-sex couples of any faith. Next slide, please. Here, the plaintiffs allege that Miracle Hill is a private agency that receives government funding and therefore should not be able to discriminate and deny them the ability to foster based on their religion or sexual orientation. Next slide, please. Similarly here in Rogers, the state defendants filed a motion to dismiss, arguing that the plaintiffs lacked standing because their injury was not fairly traceable to the state. The court, however, allowed plaintiffs to pursue claims for equal protection based on sexual orientation discrimination and violation of the Establishment Clause. Next slide, please. So next is a discussion about landmark Supreme Court cases that shaped LGBT rights in America. And this is an overview of how LGBT rights have developed over the years. With Baker v. Nelson, the Supreme Court considered the issue of marriage equality for the first time in 1972. The case was dismissed for lack of substantial federal question. In 1986, the LGBTQ rights movement was dealt a major blow when the court decided to uphold a Georgia sodomy law in Bowers v. Hardwick. Romer v. Evans was somewhat of a turning point in the gay rights movement in 1996. The Supreme Court ruled that laws could not single out LGBTQ people to take away their rights. In this case, a Colorado law did not adhere to the 14th Amendment Equal Protection Clause because of how it singled out a certain group of people. Lawrence v. 1996, we have Boy Scouts of America versus Dale. The Supreme Court found that forcing the Boy Scouts of America to readmit an openly gay Scoutmaster and Eagle Scout would violate their First Amendment right to freedom of association. Lawrence v. Texas was a significant victory. The Supreme Court ultimately eliminated sodomy laws in 2003, overruling Bowers v. Hardwick with a vote of 6-3. Next slide, please. In 2013, we have U.S. v. Windsor, which was a major precursor for marriage equality. The court decided to eliminate the portion of the Defense of Marriage Act of 1996 that defined marriage as a legal union between one man and one woman as husband and wife. In 2015, we have Oberfeld v. Hodges. A group of 14 same-sex couples and 2 men whose partners were deceased joined together and won one of our LGBTQ rights movement's biggest victories, marriage equality. In a 5-4 vote, the Supreme Court held that state officials violated the 14th Amendment Equal Protection Clause by prohibiting same-sex couples from marrying or not recognizing marriages performed in other states. And although by 2018, LGBTQ people could marry, the Supreme Court found that a baker was not required to make wedding cakes for same-sex marriages in the case of Masterpiece Cake Shop. And then we come to 2020. Recently, the Bostock case, as we've discussed, was another major victory in our movement for LGBTQ rights. The U.S. Supreme Court holds that Title VII protects gay and transgender workers. At this point, I'm going to transition to my colleagues from the United Kingdom.
The European Convention on Human Rights is a key document over here. It was entered into in 1950 when the Council of Europe was formed after the Second World War to deal with the various fundamental freedoms and human rights. And that convention, which from its date has freedoms relevant to LGBTQ people, but certainly wasn't drafted with them in mind, but it has provisions relating to private and family life, marriage, and freedom from discrimination. I should just explain that's completely separate from the EU. There is a requirement that EU states must be members of the Council of Europe and adopt the European Convention on Human Rights, but they are separate bodies, and a separate court, the European Court of Human Rights, hears cases regarding breaches of that convention. Those are cases brought by individuals against states. That's why you'll see cases against the United Kingdom, and it has power to fine states that have breached the convention, but it can't actually change the underlying law. So the pattern tends to be that after a decision that goes against a state, it prompts legislation probably across Europe to address the point. The UK went one step further in 1998. We adopted the Human Rights Act, which gave those convention rights, put them directly into UK law, made it unlawful for public authorities to breach them, and required courts to interpret law consistently with those convention rights. If it couldn't do so, our courts make what's called a declaration of incompatibility. It doesn't change the law, doesn't stop that law applying, but it's a signal to the government that it needs to amend some problem with law. So we'll often see these decisions result in either a finding by the ECHR or a declaration of incompatibility now by a local court, and then we see sort of legislation come in afterwards to fix that issue. So with that's the introduction to what we're going to be talking about. I'm going to pass you over to Olivia to talk about the first two of the four cases we're going to be spotlighting.
William. So our first landmark case is Dudgeon v. the United Kingdom. In terms of the legal background to this case, legislation introduced in the UK in 1861 and 1885 made sexual acts between two men illegal with a maximum penalty of life imprisonment. In 1967, a new law was introduced in England and Wales, meaning that it was no longer a criminal offence for two consenting men over 21 to engage in same-sex acts in private. This position was then extended into Scotland in 1980. By contrast, in Northern Ireland, the law remained unchanged because at the time, Northern Ireland had a separate parliament. So the applicant in this case, Geoffrey Dudgeon, was a 35-year-old shipping clerk and gay activist in Northern Ireland. In January of 1976, his home was searched by police under the Misuse of Drugs Act 1971. During the search, his personal correspondence and diaries in which he described homosexual acts were found and seized. As a result, he was interrogated by the police for 4.5 hours for sexual practices. The police file was then forwarded to the Public Prosecution Service with the intent of charging Dudgeon with the gross indecency, although it was later decided that prosecution wouldn't be in the public interest. In May 1976, Dudgeon then filed a complaint against the UK with the European Commission of Human Rights. He claimed that the existence of laws in Northern Ireland criminalising same-sex acts between consenting men, combined with the police investigation, constituted unjustified interference in his right to a private life under Article 8 of the European Convention. He also claimed that he had suffered discrimination in breach of Article 14 of the Convention on the grounds of sex, sexuality and residence. So the European Court in this case held by 15 votes of court that the laws in Northern Ireland did in fact unlawful interference with Dudgeon's right to a private life. This case was a landmark case for LGBTQ in that it led to the decriminalisation of consensual sex between two men in Northern Ireland in 1982. And it's also been used as a legal precedent to protect gay rights across Europe and compel similar law reform in other jurisdictions. Our next case is Smith and Grady v. the United Kingdom. The applicants in this case challenged a Ministry of Defence policy that prohibited gay men and women from serving in the armed forces. The policy stated that homosexuality is incompatible with service because it can cause offence, induce ill discipline, and damage morale and unit effectiveness. The first applicant, Jeanette Smith, joined the Royal Air Force in 1989. In 1994, a woman anonymously telephoned the RAF alleging that Smith was a lesbian. Smith was questioned by the service police, who asked her a series of intrusive and quite offensive questions, including names of previous partners, her HIV status, if she liked girly games like netball, and whether she was in a sexual relationship with her foster daughter. Smith admitted she was gay and was discharged from the RAF later that year. The second applicant, Graham Grady, had been a member of the armed forces between 1980 and 1994 when he was discharged following disclosures about his sexual orientation. He was again subject to the same degrading investigation as Smith. Both applicants in this case had exemplary service records and sought to challenge the Ministry of Defence's policy around gay people serving in the military in the domestic courts of England and Wales. They argued that the policy was irrational and a breach of their rights under the European Convention on Human Rights, in particular, the right to a private life. The applicants lost their case in the High Court. Although the court urged the Ministry of Defence to revise its policy in light of changing attitudes towards LGBTQ rights, it was unable to judge against the government because the role of the courts in political matters was to uphold government policy. The court could only intervene where the government policy was irrational, and it didn't consider this to be the case. Also, at the time of the judgment, the Human Rights Act hadn't been enacted to bring the European Convention into domestic law, so the applicants couldn't rely on their convention rights. The Court of Appeal later dismissed the case. The applicants then lodged complaints with the European Commission, who referred the case to the European Court of Human Rights. The European Court found that there had been a breach of the right to a private life under Article 8 of the European Convention on Human Rights. This finding was based on the extremely intrusive nature of the investigations and questioning carried out by the military police. The court also held that there had been a violation of Article 13 of the Convention, and that the applicants didn't have an effective domestic remedy. The decision of the European Court ultimately led the UK government to adopt a new armed forces policy in January 2000 and to lift the ban on gay men and women serving in the military. I'm going to hand back to William, who's going to go through the remaining landmark cases.
Thank you very much, Olivia. I'm going to turn now to the case of Goodwin and the United Kingdom, 2002, which was a key trans right decision in Europe. Christine Goodwin was born in 1937 and had transitioned, was living as a woman. She claimed that her inability to legally change her gender caused her discrimination and sexual harassment at work each time her trans status was discovered through official papers. In addition to that, she complained that the state would often write to her as if she was a man, and she objected to the fact that she was not lawfully allowed to marry a man. The European Court of Human Rights agreed that there had been a breach of her human rights, in particular her right under Article 8 to a private and family life, and also her right under Article 12 to her right to marry. The right under the convention is a narrow one that's been found not to support gay marriage. It's very much just a right for a man to marry a woman to marry a man. But Ms. Goodwin successfully argued that she was a woman who wished to marry a man and was prevented from doing so. That finding led the United Kingdom government to pass the next year the Gender Recognition Act, which gave the right to legally change gender following gender reassignment surgery, including the provision of a new birth certificate showing the new gender. Effectively, all rights would be the same as if one had been born into that gender, with one key and very British exception which concerned peerages. It didn't affect the ability to inherit a title. So if the daughter of a lord transitioned, it would not then be possible as his son to inherit the title. And the fourth and final of the cases we're going to spotlight in this review is Bull and another and Hall and another. Here's a case from 2013 and bringing up the concept of discriminatory provision of goods and services to LGBT people. In this case, a gay couple wished to stay in a room and share a bed in a guest house, and this was refused. The Christian couple who ran the guest house explained that they would not allow any unmarried couple to share a room. It wasn't particularly because these people were gay. Now, as it happened, the gay couple at the time were in a civil partnership. At that stage, the law in this country did not allow gay marriage. It allowed a civil partnership, which gave very much the same rights. So it was effectively just not possible for these two who have married. As the case went up the courts and ended up before our Supreme Court, the argument was made on behalf of the Christian couple that this was not a direct form of discrimination. Their issue wasn't these people were gay, it was that they were unmarried. And that to the extent that this was only an indirect discrimination, that could be justified by their religious beliefs. Now, the Supreme Court unanimously rejected the view that indirect discrimination of this sort could be justified by religious beliefs. But a majority went further and said that actually this was a form of direct discrimination. Their analysis was that effectively the policy adopted by the guest house owners meant that they would allow straight couples to share a bed in certain circumstances, but would never allow a gay couple to share a bed, and on that basis amounted to direct discrimination. That can be contrasted with our own sort of cake case, Lee and Asher's Baking Company, case from 2018 involving a Belfast bakery that refused to bake a cake with the message support gay marriage on the basis that that was offensive to their religious beliefs. The Supreme Court here unanimously adopted the same approach that we saw Wanda talk about in the United States. There was no refusal here to bake cakes for gay or other people with protected characteristics, and it wouldn't be appropriate to force people to promote a belief or opinion they disagreed with, and accordingly it was justified to refuse to bake that cake. Now, Olivia is now going to take us through a timeline that puts these cases into context of the evolving LGBTQ rights landscape in the United Kingdom.
So the LGBTQ landscape in the UK has changed quite substantially over the last 50 years. In terms of how far we've come, this slide sets out some of the key dates for LGBTQ rights established by case law and legislation. To give it some context, up until 1967, sex between men was illegal in the UK. By contrast, the position for women was never put into law out of concern that legislation would only encourage women to explore their sexuality. In 1967, consensual sex between two men over 21 and in private was decriminalised in England and Wales. This was extended into Scotland in 1980. Then in 1981, the European Court of Human Rights held in Dudgeon v. the UK that the criminalisation of consensual sex between two men in Northern Ireland was unlawful. As a result, the law in Northern Ireland was changed in 1982. In 1994, the age of consent for gay men in Scotland, England and Wales was reduced from 21 to 18. In 1999, in Smith and Grady, the European Court of Human Rights found that the investigation into and discharge of military personnel based on sexual orientation alone was unlawful. This led the UK government to lift the ban on gay men and women serving in the armed forces in 2000. Also in 2000, the age of consent was equalised. So in Scotland, England and Wales, this was set at 16, and in Northern Ireland, it was 17. Then in 2002, law was passed granting same-sex couples equal rights to adopt in England and Wales. Also in 2002, in Goodwin v. the UK, it was held that the UK government should accommodate the rights of transgender people by issuing new birth certificates and permitting marriage to someone of the opposite gender. In 2003, laws were passed to prohibit discrimination on the grounds of sexual orientation in the workplace, and also to repeal legislation that made same-sex acts illegal. In 2004, civil partnerships were introduced for same-sex couples in England and Wales, Scotland and Northern Ireland. And transgender people were granted the right to have their gender identity legally recognised. In 2007, discrimination on the grounds of sexual orientation in the provision of goods, facilities, services, education and public functions was prohibited. In 2010, gender reassignment was added as a protected characteristic, protecting transgender people against discrimination. In 2014, same-sex marriage became legal in England, Wales and Scotland, with the first same-sex marriages in England and Wales taking place on the 29th of March 2014. Finally, in 2020, same-sex marriage became legal in Northern Ireland. Ultimately, it remains very much to be seen how the LGBTQ landscape will change going forwards, but one case to watch is the case of Alfred McConnell, and I'll hand back to William.
Thank you very much. So rounding off our talk on the UK side of things with this case, Alfred McConnell is pursuing a case against the Registrar General for England and Wales. He is a transgendered man who wants to be recognised as the father of the child he gave birth to. Originally, he was anonymous, as people often are in these cases, but he's waived that in order to take his message public, and has seen sort of quite considerable media coverage recently in relation to that. He's recently been unsuccessful in our Court of Appeal, but is looking to take his case to our Supreme Court. And the reason why he lost in the Court of Appeal is that the court found that under our law, the terms father and mother are not necessarily gender specific, but do indicate sort of particular roles in the biological birth process, and concluded that a person whose egg is inseminated in their womb, becomes pregnant and gives birth to a child, is that child's mother. Looking back to that Gender Recognition Act that I spoke about a short while ago, Section 12 of that does say that the fact that a person's gender has become the acquired gender under this Act does not affect the status of the person as the father or mother of a child. The Court of Appeal said that that provision did not breach human rights law, and they declined to make a declaration of incompatibility. They felt that although they acknowledged that there was an interference with the right to private and family life under Article 8, it was objectively justified, and in particular by the use of the term mother across a whole host of legislation that, for example, provides automatic parental rights at birth to a mother. And they also considered that moving away from the terms mother and father and the meaning of those terms would have impacts on number of families beyond the applicant in that case. But that case is going to our Supreme Court. There's also a case on similar facts from Germany that's going to the European Court of Human Rights. So I think that's definitely one to watch, and that's a discussion about what the meaning of mother has in law is no doubt going to be relevant to the wider LGBT community, and indeed to other people who, for example, adopt children, who might be interested in the way that terminology is being used and stuck to. That concludes the UK portion of the presentation, and I will pass you back to Wanda.
Thank you, everyone. On behalf of my fellow presenters and McGuireWoods, I want to thank everyone for joining our CLE webinar on seminal LGBTQ legal cases in the United States and United Kingdom in celebration of Pride Month. And while we run out of time for Q&A, we have been gathering questions during the presentation, and we will send a short follow-up of answers to the attendees who've asked questions. Also, please feel free to email any of us directly with follow-up questions or comments. We would appreciate any feedback. Thank you again, everyone, for joining us. Have a good day.